Hello, and welcome to the Commercial Tenants Association's webinar programme. Today is the third in our series covering the property life cycle. In this series, we've already covered taking on and agreeing a new lease. Our last webinar was on renegotiating or re-gearing a lease. And both of these can be found on the CTA website, the cta.co.uk, in our video library. Now today we'll be covering rent reviews, mainly those that occur during a lease term, covering potential pitfalls even, risks associated with notices, the importance of professional advice, and then the standard forms of dispute resolution. Today, I'm joined again by Paul Rayburn of Rayburn Consulting, Martin McKeague of Walker Morris, and Tony Milligan, Head of Membership. Good afternoon, guys. Really, just as entering into this, that we have lots and lots of inquiries from our members, particularly about rent reviews. And I suppose the first point to get into it is when during the lease term is a rent review due? Paul, do you want to sort of add to that?
So rent reviews historically were introduced because leases were generally far longer than they are today. So commercial or business tenancies entered into really from the late 1960s right through until immediately following the recession which followed the collapse of Lehman Brothers Bank in 2008. So for that 40-odd year period, leases entered into for shops, offices, factories, whatever, tended to be 25 years in length, and a short lease would have been 15 years. So rent reviews tended to be contractually set to occur on each 5th anniversary of the commencement date of the lease. And the whole point of that rent review was really to convey to the landlord an increase in rent. It was assumed that rents would always increase, and most usually they did. So it was to convey to the landlord an increase in rent to reflect what the property would now let for. So 5 years on from the start of your lease, 10 years on from the start of your lease, and so on. And that's why they were introduced and why they occurred. Leases now, since the last recession, since kind of 2010, 2011, leases have generally shortened in length, so that now we're at a point where 5 years is fairly standard, 10 years would be quite long, as opposed to 15 and 25 historically. But even within those relatively short leases, there are still commonly, but ever less usually, rent reviews. And a rent review may fall therefore at year 3, or if it's a 5-year lease, and if it's a 10-year lease, more likely at year 5 in terms of the modern frequency of them.
Yeah, it's actually interesting to point out. My property journey started in commercial lettings in 1999, and the average lease length then was just over 16 years. Right. So sort of, and going through the 2000s, where we are today, the average lease length is just over 5 years now. So we have come a long way just in 20 years, never mind in the 40 years that you've discussed, Paul. And often as well, we're even seeing rent reviews on an annual basis, where it's written into the lease. So, I think in terms of covering that, when is a rent review due, it's going to be determined by the lease documentation and what it stipulates in that. Is that right, Martin?
Yeah, absolutely. It is going to be governed by the lease. I mean, I suppose that what you also see from time to time, you see a last day rent review. So you might find that in certain leases, the landlord sneaks in a rent review on the final day, and you might say, well, what's the point in doing that if the lease ends the next day? Well, the answer is that, as we've discussed on previous webinars, that most commercial leases will be inside the Landlord and Tenant Act 1954. So the landlord seeks to put in a last day rent review there in order to provide it with a mechanism for dealing with an increase in relation to the continuation tenancy. The reality is the landlord could probably get that increase through an interim rent application in any event. But you can see that in leases. You get a last day rent review. I mean, as Paul said, it is interesting how rent review has evolved over the years. I think we're now seeing more of index linking in relation to rents as well. And we're also, I suppose, particularly in retail, they're moving towards more of a turnover-based model, which obviously essentially is linked to the success of the business rather than perhaps what's going on in the property market in general. So it is evolving.
Yeah, and they're the mechanisms of rent review, I guess, in terms of the other one that we hear an awful lot of, and sort of is very pertinent to the commercial property industry is upward only rent reviews as well. And in every commercial entity, there's never really that sort of one biased approach for a commercial agreement as such. And sort of part of that is sort of when during that lease term a rent review is due and the mechanism. But in first instances, I guess either the landlord or the tenant has to create a notice that they are set to increase the rent, or that mechanism is enabled. And what is the legal procedure on that, Martin, in terms of a tenant will be instructed, even though it's in the lease agreement that the rent may be reviewed on an annual or a 5-yearly basis, it has to be triggered in some way?
Yeah, I mean, there's a whole range of different rent review mechanisms. It doesn't necessarily follow that it has to be instigated by a notice. Sometimes it can simply be instigated by one or other party applying to appoint an expert or an arbitrator to determine what the rent is. But yes, you're quite right, Stephen, that commonly it will be triggered by what's commonly known as a trigger notice, whether that's served by the landlord, typically as it would be, or by the tenant. But rent review mechanisms will operate in a variety of different circumstances. And one of the, I suppose, often debated topics in rent review and where disputes can arise is in the context of whether what is called time of the essence in relation to those notices. So, for example, if the rent review clause says a notice has to be served within a particular time frame and the landlord doesn't serve that notice, does that mean then that the landlord has lost the right to call for the rent to be reviewed? And that's a hot topic. So yeah, you're quite right that generally a rent review will require one or either party to serve a trigger notice, but it doesn't always follow that that's the case.
So we've gone through that there's a number of different mechanisms and periods in which a lease term sort of may be reviewed in terms of rental. I guess then it's the justification of what that increase may be. And Tony, we get an awful lot of inquiries from our members that are disputing that a rental increase may have gone up 20, 30, even 50% from the previous year. And I guess it's there's so many different what would you call it, definitions of what that rent review is based on. We've talked about it in some of our other elements of best rent, a headline rent, a net effective, or even an open market value. But how do we go about justifying that it's a correct rent?
Yeah, I think just in very simple terms, I should say that quite a lot of our inquiries at CTA come from our members and people contacting us to say that they've been told by their landlord that their rent is going up, and quite often it's going up by a huge percentage. So I think the first thing to say about that is that you don't have to accept, in normal circumstances, or usual circumstances I should say, you don't have to accept that rent that the landlord tries to impose on you halfway through the term or whenever the rent review is. You do have an opportunity to negotiate with the landlord. that may or may not be successful. But yeah, going back to your sort of question just then, you know, what sort of basis is the landlord trying to review the rent on? And, you know, if it's an open market basis, then he's going to have to supply some evidence. I'm sure Paul can talk in more detail on that. But yeah, generally what we see is landlords trying to impose rents on tenants. And, you know, a lot of tenants, you know, will roll over and accept the rent that the landlord tries to impose, but that's not necessarily what they should be doing.
And I guess it's more pertinent in the current economic climate where, you know, particularly retailers where they may have, you know, not even recovered yet, and yet they've come across a rent review and it's an upward only rent review, and they want to sort of renegotiate or want comparable evidence to say why this should be increasing. Paul, what's the sort of the process when you get involved on a rent review, that, you know, essentially a landlord's enacted and put in the notice for a rent review? What's the first element that you would sort of act on behalf of a tenant?
So this might sound relatively simplistic, but it's not. It's a rent is arrived at both when putting a property on the open market and when negotiating a rent review in much the same way, certainly in terms of the target rent when sticking it on the market and the rent you negotiate in a rent review. And that is it being a function of the size of the property. So it requires measuring, and different properties have different parameters for how they are measured. It sounds very dull. The RICS, Royal Institution of Chartered Surveyors, set these measuring parameters that we as surveyors are meant to use. So I'll take the example of a shop for the purposes of illustrating this. So the landlord quotes a rent. Let's say the rent passing is 15,000. Landlord says he wants the rent to go to 25,000. The role of the surveyor, so in my shoes on behalf of the tenant, is to say to the landlord or the landlord surveyor, thank you for your proposal. How have you arrived at it? Give me your measured floor areas and the comparables that you're relying upon. And comparables have varying degrees of quality or weight as evidence. So the strongest, and this is for me as the surveyor for the tenant to check out, you don't necessarily just trust what you are told, because there may be crucial elements missing in what you've been told, accidentally or deliberately. So it's my job to find out the facts behind the transactions that are advanced, and to find my own. There might be other comparables that have been missed out because they don't suit the landlord's case. So you're checking out the details of those comparables, who to, what lease term, is the location of that shop as good as this shop, or is it better? And if it's better, then we need to adjust accordingly. Is it a better shop, wider frontage, better configuration, no steps inside, no steps in the entrance? These kind of things all affect rental value and should be negotiated in terms of settling what rate per square foot or square meter applies to your shop on the correct floor area. And then there may be terms within our lease which are not as favourable as terms in the letting evidence. So you need to make allowances for those elements as well. So it's a set of negotiations where you, as the tenant, must seek to have, ideally, a better surveyor on your side than the landlord has on theirs. And what you're looking to do is to argue and succeed on every possible adjustment that is justified in terms of how that would otherwise apply in the open market, and to have that reflected in the end rent you agree. One brief point there, though, Stephen, you touched on the term upwards only. It is a historic concept. It is still incorporated into many leases, but I think over time is fading out. And quite simply, what it states is that at rent review, the rent will be the current open market rental value. So that's arrived at on that basis I was describing there, current open market rental value, or the passing rent, whichever is the higher. Because it may well be the case, and it certainly is for your average shop these days, that the current rental value is less than it was 3, 5, 10, 15 years ago, whatever. So the landlord gets the best of both worlds, if you like, that the rent will go up if there's evidence to support it going up. But if the evidence actually shows it should be going down, it stays the same. So that's what an upwards only rent review clause is. which is why we would usually say to tenants, look, when you're taking a new lease, either on lease renewal or brand new lease, if the landlord will not concede that the rent review will be to the then current rental value, so that means it could go up or down, if that won't be conceded, then just have a shorter lease, because at lease renewal time, you're negotiating a new lease, it will then be whatever the current rental value is, not necessarily upwards only.
Yeah, so it's taken into consideration, and this is where really I think the advice from all of us is that you should be taking professional advice in any of these negotiations, and really to sort of use the professional bodies around to help negotiate these, because as we've talked about in acquiring a lease, then essentially there are so many pitfalls in there that you need that professional support.
I think I'd sort of just add to what Paul said there. I think the important thing as well, and it comes back again, I think, to Stephen and the sorts of queries and questions and challenges you get from members, is that in a sense the rent review process is not an exercise in arriving at a rent which is affordable to the tenant. It is, although it's based on evidence, it is an objective exercise, and Paul's quite right that you need to get a rent review surveyor and you need to get one who knows the market very well, but also it's important to bear in mind that the die will generally be cast by the time you get to appoint your surveyor, because if ultimately you've signed up to a lease which has unfavourable rent review provisions, regardless of how good your rent review surveyor is, then you can only work with what he's got.
Yeah,
so that's important.
That's to add to that, actually, Stephen, that's a very fair point, Martin, because I was giving a simplistic description earlier on, but to colour in a bit from what Martin has kindly expanded on there, you could have a scenario, for example, where your lease has a very restrictive user clause, so it only allows you to use it, say, for your use, and you're a baker, for the sake of anything else. So you're only allowed to use it for that. If you then were trying to dispose of your lease during its currency, you're trying to sell it on, short of you finding another baker, you're not going to get rid of it to anybody. So the only people who are interested in taking your lease operate a pet shop, for example. If the user clause is strict and closed as a baker's shop, it's either not going to happen, or the landlord will ransom you to change that use, require a payment from you for that. Yet the rent review provisions may assume that the user clause is wide open. So you'll pay a full rent as if you could do anything that you liked with it, but the reality is it's worth far less. So those kind of anomalies can exist if you had poor or no legal advice in the initial drafting of your lease. And as Martin rightly says, no matter how good your rent review surveyor might be, your rent review surveyor isn't going to be able to fix what's already been set when the cast was die at the commencement of that lease.
That's great. And just for the audience's sake as well, if you do have any questions, please use the Q&A function just at the bottom of your screen, and any questions the panel will endeavour to ask. And as we move on from sort of that justification of rent and comparable evidence, Paul, I guess it's not just what the asking rent is. We need to be looking at also the incentives that generated that headline rent, I guess.
Yes, so to expand briefly on something I said earlier on, I said there are different qualities of evidence or classes of evidence. So, and in terms of how much strength or weight is applied to them. So open market lettings, arm's length open market lettings are generally considered to be the best measure of the open market. I suppose common sense dictates that, but you often hear rather obtuse arguments to the contrary. So open market lettings make, in principle, for the best evidence. Then what was down at the other end of this spectrum in terms of weakest or in fact irrelevant evidence, landlords will quite often say, look, I own this entire block of offices, industrial units, whatever they might be. I have number 7 on the market at an asking rental of £10 a foot. So that's what I want from you, even though you're only paying £5 now. And that's my evidence. I've got it on the market. Well, that's not evidence of anything. It's evidence of what you want. It's not evidence of what you've achieved. Or I've had an offer. It'll be claimed I've got an offer. I've got a prospective tenant going in. It's not quite the £10 I was asking for. It's £9.50. Still not evidence. It's not a done deal. So that weight of evidence is very relevant. And then in terms of answering your specific question, Stephen, please remind me what it was.
So it's the incentives that are added within
right?
to get that headline rent.
Of course. So getting back to that little example I was giving you, so landlord might say, okay, I've now done the deal and I've got £9.50 a foot for it. You find on closer examination that in fact, yes, they have got £9.50 a foot for a 5-year lease, but they've given a year's rent-free period in order to achieve that. So it's not £9.50 a foot. For want of doing crude arithmetic on it, if you get £9.50 for 4 out of the 5 years, you're only actually getting 80% of it. So that's the real rate, because on a rent review, you're not getting a rent-free period. The rent continues day to day. So it's the effective rental, the real rental, if you like, that we're looking at in the evidence, which is therefore net of those incentives that have been granted in the open market. There's a bit more depth to that, in that a landlord may be able to evidence that some or all of a rent-free period was to compensate a new tenant for the poor condition of a property, with a condition in the letting that they had to do those repairs and put it right. So that wouldn't be an incentive, that would be compensation to remedy something. But ordinarily, unless that can be evidenced and proven by the landlord, the reasonable assumption is that a rent-free concession or something else, a lump of money, it could be a lump of money to cover their shop fitting, whatever, but a concession is actually an incentive, and therefore the real rent is net of that sum, or the capital equivalent of that sum.
And I guess that then poses the question, when you take on the lease and a condition-based survey, is making sure the rent review is based on what you receive the building in, rather than the improvements that you've made. Because if you've made improvements to the property, that could increase its rental potential, but it's not something that the landlord should benefit from. But that will be determined, really, Martin, by the lease itself and the wording in it.
Yeah, I mean, your solicitor's not done a very good job if there's not a disregard in the rent review provisions to say you should disregard tenants' improvements. I think that's the short point. I mean, clearly, as you say, Stephen, the tenant should not be paying rent for its improvements. Those improvements should not be rentalised, and therefore then you would expect any any rent review provisions worth their salt to provide for that to be disregarded from the rent review calculation.
But I guess, sorry, Martin, we do see, Tony, don't we, lots of places where in the lease this is silent.
I've not seen that many, but there is always a lot of confusion as to how the rent is arrived at through the rent review clause, through the mechanism of rent review. So it's a very important point that you've made there, that there are disregards and assumptions within that clause. And it's almost like an instruction manual, really, for how the rent review will be calculated and how the surveyors will come to their opinion of value.
And actually, on that point, Tony, there was something that we were discussing the other day, actually, Martin and I, so a point that Martin made, which I think feeds into what Stephen's saying there. On the, you've briefly covered alterations there, the tenant not being charged for their improvements. But similarly, if you've taken a property on in poor repair, there might be the assumption, the perfectly reasonable assumption on the part of the tenant, that at rent review, the rent that's going to be assessed will reflect the fact that they took on a property in poor repair. But ordinarily that is not the case. As Martin covered in a previous webinar, and I'm sure we'll again going forwards when we come to dilapidations especially, the standard wording of a repairing covenant is to keep a property in repair, which implies that you're to put and keep it in repair. Moreover, a rent review clause will assume the tenant's compliance with its covenants under the lease, whether or not you have. It will assume the tenant's compliance with the covenants. So more often than not, the assumption which will be reflected in the rent at rent review is that the property is in good order, good repair throughout, well decorated, whatever, whether or not it actually is. I think that's a fair point to make.
Yeah, so sort of we've come to the mechanisms and justification and employing sort of professional advice both on the legal and the surveying background. But I guess the issue then is that, you know, the landlord is looking for an increase in rent, and the tenant either cannot afford or disputes that. What is the process in terms of that dispute resolution that moves forward, in the fact that the rent review period has come through, neither party can agree on what that new rent shall be? So what's the process that a tenant needs to enact in order to raise that further? Paul?
I mean,
oh, sorry.
Well, I was going to say that I think the starting point is that unless and until the reviewed rent is agreed or determined, the tenant continues to just pay what's called the passing rent, i.e. the rent payable as at the review date. So if nobody does anything, or the landlord and tenant just continue to sort of chew the cud over the issue, the tenant will continue to pay the old rent. I suppose it's not an entirely sort of neutral position, because of course once the rent is determined, then the uplift will then become payable, and potentially interest will become payable on that uplift as well. The general mechanism in the event of a dispute is for one or either or both parties to appoint a third party to determine what the rent is. That third party will either be an arbitrator, who typically will determine the rent based on the evidence presented to him, so comparable evidence as Paul discussed there, and taking into account the lease terms, or alternatively a third party expert who will determine it based on his own expert judgment and expert opinion. The general mechanism for an arbitrator is governed by the Arbitration Act, which has specific rules. There's limited grounds of appeal. The arbitrator also has power to award costs. And I think we'll come on to talk a little bit about Calder Bank offers. And the arbitration process, therefore, then is one regulated by the Act. The expert determination process is not governed by the Act. I mean, there's no hard and fast rules, Stephen, really. I mean, some leases contain reference to arbitration provisions, some contain reference to expert determination. I suppose on balance, Paul may have seen different things, but I would generally see more arbitration referral clauses than I would expert determination referral clauses. And at the end of that process, then you will have a determined rent, and that rent will then be payable. And obviously, if, as is not uncommon, some period has elapsed since the rent review provision, can sometimes be years, then the tenant will then have a fairly short space of time within which to pay the uplift. Otherwise, the landlord is then entitled to sue to recover that uplift.
And I guess, Paul, you know, what is that? You know, if a tenant is looking at dispute, you know, do they go down the arbitration route or the independent expert? You know, what's the sort of the weighing of those? Is one more costly than another, or is one more binding than?
No, I'll briefly cover that. I mean, there isn't a one size fits all, but there are some general principles. To add a little to what Martin was saying there, in terms of how that dispute resolution process works in practice, most business tenancies in the rent review clause have a provision which allows either side, landlord or tenant, to apply to the Royal Institution of Chartered Surveyors to have that third party arbitrator or expert appointed. The RICS have a form online on their website. You fill that form in. You don't have to be a surveyor or a lawyer. Anybody can do it. You pay the fee, which is a set sum, about £400 now, I think, and they will then appoint, whichever the lease says, arbitrator or expert to decide your rent review. In terms of which is better, arbitrator or expert, we could talk about it all day, but in a nutshell, I am an arbitrator and an expert, and my preference of which role delivers the best value, I would say arbitrator more often than not, because there is statute governing the conduct of an arbitrator, one of which is that the arbitrator therefore has to give detailed reasons for the decision that is reached in terms of the rental. So at least you might not be happy with it, but you're not in the dark. Whereas with an expert, you can just end up with a sum. Both charge much the same. Their fees will be much the same, so you might as well get more for your money if you like. When I said earlier that the standard clause will allow either side to apply to the RICS to have that arbitrator or expert appointed, some leases don't have that. They just allow the landlord to do it. Don't accept a lease like that if you're negotiating it. You should have the right to apply yourself as a tenant. The reason in particular that you might want that is a rent review might be passed. A rent review date might be passed. Landlord hasn't triggered it. You've got that hanging over you. You want the certainty. And especially if you're looking to dispose of your lease, sell your business and dispose of your lease, it can be very difficult to do so if there is an outstanding rent review, because whoever's going to acquire it is worried that the rent might go up and they don't know what the heck it's going to be. So your way of resolving that as the tenant in that position is to apply to the RICS and have an arbitrator or expert appointed. And often just that action, having them appointed, is enough to cajole the landlord into action to say, oh yeah, okay, I concede it's nil increase, your rent's staying the same, there's your rent review memorandum, it's now done. So it's often a useful method just to bring about certainty.
That's great. And the role of the retained surveyor then in that process, is that something that's usurped by your surveyor who's acting on your behalf, or do they work?
No, so if you either do have a surveyor already acting or you don't, then you do need one going forwards, because whether it's an arbitrator or an expert, Martin did make the point that strictly speaking, an expert should go and get their own evidence and make their own decision, but in practice they don't really. They rely on each party's representative or surveyor feeding them that evidence. So you will be disadvantaged as the tenant if you just stick in a few notes yourself or do nothing, because it's reasonable to assume that the landlord will have a surveyor advancing a whole load of evidence, but of course only evidence that suits their side, so or that's not necessarily complete. So therefore the arbitrator or expert isn't necessarily getting the whole story. In theory, you can sue an expert if they get it wrong. You cannot sue an arbitrator, they have immunity. But in reality, are you going to sue an expert? The cost, stress and hassle of doing so, you might as well make your best endeavours to assist them in getting it right in the first place. And you'll do that by having a surveyor representing you in making representations to that arbitrator or expert.
And I suppose it is important to get that professional support, because there are sometimes time elements that if it's not notified or you don't reject the rent increase, then the landlord is able to enforce that because it's written in the lease in that way. There
is that, Stephen. But I mean, it's relatively rare, but there is that risk. There's also the risk, though, that with an arbitrator or an expert, they set a timetable for when they want certain things by. And the normal conduct of that is it's all done on a written basis. There's no formal hearing. That's rare. So they require evidence or a statement, a report from each side as to what the rental value will be. They then exchange that and you get your chance to reply to it. But it's a set period to reply, commonly only 2 weeks. So if you miss that, you've missed your chance to reply, and that might prejudice you in terms of where the rent ends up. And there are issues, as Martin touched on earlier on, where we might come to the making of offers to protect your position on costs, because the lease, if it's an expert, or the Arbitration Act, when it is an arbitrator, does entitle or empower that third-party decision maker, the arbitrator or expert, to apportion costs between the parties, and at the extreme, for all costs, so the other side surveyor's fees, as well as your own, and those of the arbitrator or expert, to be paid by the loser in that situation. So we might need to talk about what at law defines what a loser is.
So again, I think looking at those costs, one is often it's determined in the lease itself whether those costs are covered by the tenant or shared between the tenant and landlord when going into those reviews. But also is then, if in dispute, Martin mentioned it, the Calder Bank offer is almost really to secure your position that you believe you've negotiated a fair rent, and to have that before going into that arbitration process. Correct.
So I'll leave it to Martin to explain what a Calder Bank offer is. I'll give my lay explanation of it for now, and I'll use a real world example. So I could be acting for the tenant of a shop. Their current rent is £20,000. Landlord is determined to get £25,000. My interpretation of the evidence is, in fact, that it's really only worth rental-wise now 15. It's worth less than the passing rent, but sadly, it's an upwards-only rent review clause. Off we go to arbitration. This is costing my tenant client quite a lot of money. Half of the arbitrator's fee, which may be £2,500–3,000, £3,000, my fee, which may be a similar level. So quite a lot of money to end up with the rent staying the same where we always thought it should be, in our opinion. We would therefore serve what's called a call-to-bank offer, which is a particular style and form of offer on the landlord, basically saying that from the rent review date, the rent should be the same, and requiring that they accept that offer within a specified period, usually 21 days. And if you don't accept it by that date, you'll pay all of our costs going forwards. So therefore, if it goes to arbitration, arbitrator makes the award, and the award is, let's say, £18,000. So therefore the rent stays the same at 20,000. We have won. And in those circumstances, we would then, at that point, show the arbitrator the offer that was made, sent by recorded delivery, and say, look, the landlord had the opportunity to settle us long before now and avoid all of these costs. So why should it cost us anything to have achieved this? And in those circumstances, ordinarily, all costs, therefore including my fees and all of the arbitrator's fees, would go to the other side to pay.
I think, yeah, I don't have a great deal to add to what Paul said there. I suppose just one point is that the nature of a call-to-bank offer is that it's an offer made without prejudice, save as to costs. And what that means in practice is that the offer can only be brought to the attention of the expert or arbitrator when it comes to determining costs. So the expert or the arbitrator will not see that offer unless and until he or she is asked to determine costs. It won't be made available to them at the time they make their actual determination. And I think the important point is that arbitrations, expert determinations can be very expensive. I mean, one issue we haven't really touched on is Paul's talked about there being disputes in relation to comparable evidence and also valuation matters, but you do get disputes as well in relation to the interpretation of the lease. And those disputes can involve the arbitrator or the expert having to involve what's called a legal assessor, because essentially the arbitrator and expert will be a person who is expert in valuation matters. And they will need to lean on a lawyer or a barrister to provide assistance in relation to determining the meaning of a lease. So, for example, there might be a dispute over what a particular assumption means, or the effect of a particular disregard, which can have a very significant effect on the level of rent. So these exercises can be expensive, and it's therefore important to make a well-pitched and realistic call-to-bank offer as early as you can in the process to give yourself that protection on costs.
And I guess, that's with regards cost, that's often the worry of a tenant, particularly a small owner occupier or small business person, where, particularly in the current market where they are struggling, is, can they afford to go to court and the court proceedings, or do they just negotiate that rental in order to sort of be able to continue to trade? And I guess that's always something that they need to weigh up.
It's a common misunderstanding, though, Stephen. I think you yourself used the term there, going to court. So I think landlords often build the fear factor of arbitration. It's just like going to court. It's nothing like as terrifying as that. Like I say, it tends to be done on a documents only basis, which means that if you are the arbitrator, I'm sending you a report, Martin's acting for the landlord, he sends you a report, and the surveyors make those representations. Lawyers can be involved, as Martin rightly says, to interpret complex rent review clauses. It's fairly rare, especially with smaller businesses and smaller, more simplistic leases. It really is more a matter of interpreting what evidence is available as best you can and arguing that as best you can. And that really comes down to experience and understanding of how that market is operating, how the market on a macro level is operating around the country, and then more specifically micro to the environment that it's in, the housing, the industrial estate, the shopping parade, wherever it is. and it's presenting that evidence. But the fear thing that is often built is deliberately exaggerated to, certainly in my experience, to all but browbeat a tenant into just paying a higher rental to make it go away. But the problem with paying a higher rental is it's a false economy, because obviously you've got that compounded over the years ahead. You probably then got another upwards only rent review clause. It's not going to fall back. And also the more you over rent a property, the harder it is to get rid of it if you want to get rid of it during the currency of that lease by selling your business on. So there are actually sound reasons to defend, robustly defend your position, or at least have advice as to how strong your position is to defend it. It is possible that the landlord's quoted you £22,000, your own surveyor goes around and looks at it and says, actually, I don't think I can better that. In fact, if the landlord was to get proper advice, he's not so very well advised, it could be 25. That could happen. But you're only going to know that by getting informed advice.
I think one point I'd add, I suppose, is that rent review is, I suppose, like any, Paul's quite right, that it doesn't involve going to court, and the arbitration process, whilst a judicial process, is more informal and it's dealt with generally on paper, so the costs aren't quite as frightening as they would be if it was going to court. But I suppose rent review, like any dispute, does involve a lot of psychology, and people, as myself and Paul come across regularly, want certainty. They want to buy that certainty, but then they're prepared to pay a little bit more sometimes in order to buy that certainty. But it's almost impossible, isn't it, really, to make any informed decision as to what you should do or what you shouldn't do without actually taking proper advice. But people do that, and I do think if we take what we take away from this, I would have thought, is where you need to get proper advice at two stages. One, where you're drawing up your lease to make sure those rent review provisions are balanced, and the second point is then when you come to actually determine what that rent is.
A question that's come in, and Tony, it might be worth some similar ones that we've encompassed from membership, is that does a landlord need to give a tenant any amount of notice ahead of a rent review?
Yeah, well, we do get these sort of inquiries quite regularly, and I guess the simple answer is it depends. I think, Martin, were you going to jump in there?
Well, I was going to say, I suppose in a sense of the tenant will already know when the rent review date is, because the lease will say that. It will say generally the 5th anniversary of the term and every 5th interval thereafter. You'll know what the rent review date is. The landlord might be minded to let that date slip on if it can, and generally the tenant will receive some notice, but often not very much notice. The landlord might be required to give a trigger notice, for example, providing a rent, and the tenant might have a short period of time, maybe 28 days, maybe a couple of months, to file its counter notice. So often it won't get a great deal of notice, but equally it will know when the rent review date is, because the lease will tell it that.
And is there a number, if I can get my teeth in today, is there a number of common areas that we see in dispute, Paul and Tony, that are often the main areas where, you know, this element and conflict sort of generates from?
Certainly in my experience, it's the quality of evidence thing. There are so many locations now where, because of COVID, certainly in modern times, because of lockdowns, there's what I call a transactions famine. So there have been very few lettings, if any. So the problem then is the landlords. You know, when you're claiming something, you have to evidence it. So it's the landlord that's claiming the rent is going up. So hence my point about I'm asking this rent on this property, or I've had an offer for this rent down here. You know, is it, whether or not it's true, it's not a deal. It's not the market operating. It's just somebody sniffing around potentially. It's not a deal. So the arguments I find these days primarily focus on the quality, if any, the quality of evidence, if any evidence that's presented, and a landlord's insistence that effectively that because they want an uplift, they're going to get one, and that isn't good enough. And not only is it not good enough to me, it certainly wouldn't be good enough to any arbitrator or expert in determining that rent. So those are the primary issues of what makes this adversarial process all the more heated, I would say.
And Tony, can you think of any sort of common themes that tend to come up from advice being sought by members?
Yeah, I mean, it's always going to be the level of rent, you know, that's going to affect the tenant's business going forward. And, you know, as Paul said there, you know, the quality of the evidence that the landlord's trying to introduce should always be viewed with a certain amount of suspicion. And that's where your surveyor will come in to support you to be able to interrogate that evidence. And as Paul said, you know, earlier in this webinar, that, you know, that there are varying degrees in terms of strength of evidence, and even when you look at individual comparables, you know, there are differences in terms of, you know, what can be applied to your particular situation or circumstances. So yeah, it's always worth taking that advice, taking the professional advice, particularly where you think that, you know, the landlord is trying to take advantage.
And I guess it's sort of really understanding what the mechanism is provided for in the lease itself.
Absolutely.
So, and if I sort of was to ask one final comment or one takeaway from today's webinar on rent reviews, Paul, what would it be in terms of one takeaway for a tenant who's maybe just about to come up with a rent review or have just been served a rent review? What's one takeaway from today's event that they should really be thinking about?
I'm bound to say it, and it will of course appear utterly self-serving, but it is get advice from a surveyor who specialises in rent reviews. So not necessarily the local residential agent who might dabble in rent reviews. You need advice from a surveyor who specialises in rent reviews, ideally of the type of property you occupy. They don't have to be locally based. A very good rent review surveyor who operates nationally is better than somebody who dabbles in them based locally. They need to understand the nuances of the clauses, the leases, the market, and your property in particular, and also how to work the arbitration and third-party process should it end up going that route. They need to have a strong understanding of Calderbank offers and how to protect your position on costs. So get advice in any rent review. Otherwise, I think the likelihood of oversettling it, and oversettling could even be a few £100s, which all adds up. I think the likelihood of oversettling it is high. You know, I don't purport to know the business of whichever tenant I'm acting for. That's their expertise and specialism. Similarly, I think to dabble in something that you're not experienced in carries obvious risks.
Yeah, so I guess, you know, market knowledge, both geographic and sector specific, is quite key in that negotiation process. Which is what a rent review surveyor makes their living out of knowing. All of the nuances that factor into that, so that the lease covenants, the third party process, the market drivers on a national basis. Great, thanks for that, Paul. And Martin, same question to you really. One takeaway for, you know, a tenant who's you know, worried about a rent review upcoming or has been served a notice.
Well, I think probably 2 points, which one is a sort of variation on what Paul has said. I think it is a false economy not to spend money on getting some proper advice. I think you can do it yourself. In my experience, you will be far better prepared and better armed with that advice. And I think the second point is just a general point to try, and these are emotive issues at times, aren't they? But this is not an exercise in arriving at a rent which is affordable to the tenant. This is an objective exercise. There's a legal process to be gone through. And I think if you can try and take that dispassionate view into it, then you keep a clear head and you're better able to focus on the nuances of the negotiation.
That's great, Martin. And the same to yourself, Tony. And I guess where Martin's mentioning there is taking in that emotional element away from the negotiation is often key.
Yeah, absolutely. And, you know, you may get a horrific shock when you receive the landlord's quoting rent. And I guess my takeaway, as I said initially, is that you don't always have to accept that rent. And that ties in quite nicely with what Paul was saying, is that, you know, you should take professional advice on rent reviews. And it's worthwhile doing it quite early on as well, you know, just so you get a reasonably good idea as to what you're in for when that, you know, rent review date arrives. And, you know, that just goes down to business planning, really, in terms of, you know, knowing what your outgoings are going to be, you know, 6 months in advance, say.
Right. Well, thanks, panel, for that. If there are any questions, then sort of all our details will be left at the end of the screen. We continue with the property life cycle series. With the 3rd of November, we have lease renewal, followed then finally by the end of the life cycle with a webinar on the 17th of November on dilapidations. So with that, thanks, panel. Thank you for attending, and we look forward to seeing you on the next event.
Thank you.
Thanks, everyone.